Welcome to my YouTube channel, Legal Information Law Insights. I am Advocate Mukund Mahajan. We have now reached stage 13 in our series 18 Stages of a Civil Case in India. Today's stage is one of the most crucial and decisive moments in the entire civil trial process: final arguments, where both parties summarize their case before the court. What are final arguments? Final arguments are the oral submissions made by the advocates of both parties. Here, each side analyzes the evidence, interprets the law, and tries to convince the judge in their favor. The key objectives of final arguments are to connect pleadings, issues, and evidence, interpret statutory provisions and relevant precedents, highlight contradictions or admissions from the opposite party. Legal framework. Under the Civil Procedure Code, 1908, Order 18 Rule 2, 1, and Rules 2, 3A, 3D, govern the right of a party to begin the final arguments and to reply after the opposite side concludes. The Bharatiya SaAkshya Adhiniyam, 2023 plays a crucial role at this stage as it emphasizes the admissibility of evidence, the burden of proof, and various legal presumptions that affect the outcome of arguments. Additionally, certain judicial directions issued by high courts or by the presiding judge may require parties to submit written arguments, depending on the nature of the case or court procedure. Sequence of final arguments. 1. Plaintiff's counsel begins first. Summarize the case, evidence, and issues framed. Relies on documentary and oral evidence. Cites relevant judgments and precedents. 2. Defendant's counsel presents counterarguments. Disputes the plaintiff's claims. Highlights weaknesses in the plaintiff's evidence. Supports arguments with their own evidence. 3. Plaintiff's rebuttal, optional. Allowed if the court permits under Order 18 Rule 2, 3D. Limited only to responding to defendant's contentions, no new points allowed. Bharatiya SaAkshya Adhiniyam, 2023 Key relevance. Under Sections 104 to 114 of BSA 2023, arguments must focus on burden of proof and presumptions, validity of electronic evidence, Section 63, 4, admissibility of digital exhibits, relevancy of facts, Sections 5 to 16. These sections help shape the strategy regarding how each party has discharged its burden. Example: property dispute case. Imagine a case where the plaintiff claims title by adverse possession. During final arguments, the plaintiff's counsel relies on documents showing continuous possession, electricity bills, and 2 Supreme Court judgments. The defendant's counsel challenges hostile intent, points to joint ownership claims, and disputes the credibility of the plaintiff's witnesses. The judge considers both sides, but ultimately favors the party that provides stronger legal reasoning backed by consistent evidence. Advocate's preparation tips. Before presenting final arguments, an advocate should organize pleadings, issues framed by the court, list of documents and exhibits, summaries of cross-examination, important judgments with citations and headnotes. Preparation should include a 10-minute introductory outline, issue-wise analysis, 1 page per issue, a list of relevant judicial precedents, optional tools, PowerPoint, timelines, and flow charts, if permitted by the court, especially in commercial cases, written submissions, if required. Certain courts, particularly commercial courts or high courts, may require the parties to submit written arguments. These written submissions must follow a clear structure. They should begin with a title page containing the names of the parties, the case number, and the stage of proceedings. This is followed by an index that provides an issue-wise breakup for easy reference. The body of the written submissions should consist of well-organized, numbered paragraphs supported by relevant legal authorities and citations. Finally, the document should end with a conclusion, presenting a concise and clear prayer for relief. Judge's role during final arguments. The judge may ask clarification questions, Stop irrelevant arguments. Take notes for writing the judgment. Fix time limits for each party. Mistakes to avoid in final arguments. Avoid the following mistakes: citing judgments without reading their factual background, arguing irrelevant issues not framed by the court, repeating recorded statements instead of legal analysis, presenting arguments emotionally or aggressively without factual support. Summary: Stage 13 Final Arguments. In final arguments, the plaintiff begins the presentation, and the format is primarily oral, although written briefs may also be required depending on court directions. The purpose of this stage is to summarize the entire case and establish the key legal points in favor of the party. The arguments are guided by the provisions of Order 18 of the Civil Procedure Code along with relevant sections of the Bharatiya SaAkshya Adhiniyam, 2023, sections 5 to 114. During this process, the court acts mainly as a passive listener and note-taker, carefully recording the submissions made. Once both sides conclude, the matter is reserved for judgment. Pro tip: always rely on judgments from Supreme Court of India, the concerned High Court, preferably recent ones. Landmark case KK Velusamy vs. Palnisamy, interpretation of Order 18. If you found this information useful, please like, share, subscribe, and press the bell icon so you can receive more such important legal videos in time. I assure you that I will continue to provide accurate, lawful, and research-based legal information on various topics through this channel. Your support means a lot to me, so I humbly request you to stay connected with this channel. By joining this channel, you can also receive special legal information and membership benefits. Thank you very much for watching this video. See you soon in stage 14 of our civil case series. Jai Hind, Jai Bharat.